Hi again, Attorney Steve Vondran. We are talking in this video about FRCP Rule 65, Temporary Restraining Orders and Injunctions. This is FRCP 65, Federal Rules of Civil Procedure. So without further ado, let's head to the Attorney Steve litigation whiteboard. Okay, let's back this puppy up here. And we are talking in this video about injunctions in FRCP 65. This is when your business is involved in a dispute, perhaps with another company, and you want to stop them from doing what they're doing. Maybe they're making illegal copies of your software and they're selling them on the internet. Okay, maybe they're selling them on eBay, Amazon, or Craigslist, and you want to stop them immediately because they're causing your company damages. One way that you would do that, you could send them a letter, a demand letter, please stop. If you don't, we're going to sue you. But that doesn't always work. If it doesn't work, you may need to follow the timeline here. Okay, so I'm going to walk you through some possible scenarios of how this may work. Typically, you would want to file your complaint. Okay, your complaint. Let's say in this case, you're talking about copyright infringement. This company is reproducing your software or you're using your code in their software infringement. This is just one example. There's literally thousands of examples you could come up with. So you've asked them to stop, they dispute it, they think it's their own independently created code, so forth and so on. So you file a complaint. Your complaint would allege your causes of action, okay? That is what you're suing for. Some people would call them your claims or your counts. So say you would allege your copyright infringement in detail, lay out the facts, your factual allegations in the complaint, okay? So you want to be very specific and make sure you're hitting each of the elements of copyright infringement. They copied my software, they're using my code, it's on their website, it's being sold on Amazon, attached as Exhibit A picture of them selling it, so forth and so on, whatever the case may be. So you're going to file your complaint. Now I put in this checkbox here, verified. Maybe a lot of people don't know what a verified complaint is, but you can file a complaint that is verified. That means under penalty of perjury. So when you do that, the court can consider your complaint to be evidence. It can be sort of a declaration or just like an affidavit. So this might help you when you're seeking a TRO, a temporary restraining order, if you can't get in contact with the other party for some reason. So we'll talk about that later. But one thing you want to consider is whether or not you want to do a verified complaint. So I'm just putting that up on our checklist, okay? So we discussed that. So you file your complaint, you file your summons, you're serving it on the other parties. Meanwhile, now you say, I need to make sure we're getting our TRO, our temporary restraining order, okay? A lot of people know this with spousal actions where somebody is stalking you and you want a restraining order. It's similar to that. But in the business context, we refer to that as a temporary restraining order. Now, that is when you want to immediately stop something. So you want to go into court. This is sort of like an emergency type of action. First thing I always advise, check your court's calendar. If you're in a federal court like you would be in a copyright action and where FRCP 65 would apply, keep in mind the federal rules are when you're in federal court. If you're in a state court somewhere, your state court rules of civil procedure are going to apply. So this is when you're in federal court, like your trademark, your copyright cases, your patent cases, lots of these end up in federal court. So FRCP would then apply, okay? But check, get your court dates, find out when the judge hears these. Some courts only hear them on certain days. They may hear them only on Tuesdays and Thursdays, so forth and so on. Check your court calendar, call the clerk, find out what the procedures are. If you end up with a particular judge assigned to your case, check their court rules. They may have special rules. You need to follow the court's rules, okay? But anyway, so now you get to the point where your complaint is filed. We're good there. Now you're going to enter into this area right here, which is what I call the putting it all together. You're going to need these documents to support your case. I always tell people getting an injunction or TRO is not a simple task. There's a lot of work involved, okay? So you're going to probably let's say probably, you're going to try to meet and confer with your opposing parties. If they have counsel, you want to meet with their counsel over the phone, and you want to try to discuss, the time for the hearing, where it's going to be, discuss your grounds, so forth and so on. Meet and confer with them, okay? So you're going to want to give that a try. Now, sometimes people are hiding out, you can't find them, they won't talk to you, they won't pick up the phone. So in these circumstances, you need to document your attempts to call them, attempts to email them, fax them, whatever you've tried to do. Try to document and show the court that you were trying, because courts really want this to be an adversarial process where the two parties are, duking it out together, let's just say, for lack of better words. But they want that adversarial process. So if you're not giving the party notice, you may think you're being clever, but the judge isn't going to like it. The judge is going to want you to say, did you try to serve them? Did you show them your documents? Did you discuss this? So you want to have a nice paper trail of your efforts to meet and confer. Okay, so that's your first thing in regards to the TRO. Now bear in mind also, the TRO is usually just a short-term, preserve the status quo kind of thing until the preliminary injunction hearing can be held. So it's kind of a two-step process. One is get the TRO in place. The second is get prepared for the preliminary injunction hearing. This is where the other party's going to be there, most likely, but they're probably going to be there because you're going to serve the papers on them. So step one, TRO, let's talk a little bit more about that. You need to be able to establish to the judge that there really is no adequate remedy at law, that in other words, just suing for money damages isn't going to suffice. It's not going to provide you the relief you need. In the situation I mentioned where somebody's outselling your software, maybe they're trading off your trademarks as well. You need to get that stopped immediately. So you may need to make the case to the judge. You will need to make the case that you will suffer irreparable harm if this isn't stopped, and have your what we show here, some evidence. Okay, we have up here evidence. These are more things you're going to want to have. Declarations from people. Your software designer, I coded this, this is my code, blah, blah, blah. Request for judicial notice. We're going to do a whole nother video on request for judicial notice because it's very important. In fact, I have to put that on my list, but request for judicial notice is something that can be used as evidence, things that are not reasonably disputed, things that come from government sources, okay? So there's a wide variety of things that can be used as evidence to help you support your claim that there will be irreparable harm. The judge is going to want to see something pretty solid and significant before granting an injunction. So you're going to want to talk about your irreparable harm, no adequate remedy at law. In other words, sitting around and suing him for money damages, waiting around for another year while they sell all my software and dilute my brand is not going to help me. Okay, so you want to be able to show no adequate remedy at law. And very, very important is you're going to need to be able to show, I have LOSOM, just the term I've always used, likelihood of success on the merits of the case. Likelihood of success on your causes of action, okay? You need to be able to show the judge, I'm going to succeed. I'm very likely to succeed, in other words, okay? And if the judge is convinced, then you may be able to get the injunction. You may also need to show that there are significant questions of law at issue. You may need to show that the public interest is supported, and you may need to be able to show some of these other factors, okay? But these are kind of the big ones: irreparable harm, the likelihood of success on the merits, the two most important things I think that you need to be thinking about in these kinds of cases. So you wrap up your TRO application, you serve it on the other side. Usually you'll go in and argue that in front of the judge. The other party may be there, they may not be there, they may be allowed to appear by phone. So you really don't know what's going to happen, but if you've tried to give notice and serve the other party, then they might be present. So you could be arguing by yourself, ex parte as we call it, just you in the court, or you could have yourself and the other parties in the court, okay? So that's it. If the judge is convinced that you have something solid, then you can get the TRO. That is a short term. That is a short term, usually 10 to 14 days, or as may otherwise be prescribed by the court. Okay, so short term TRO, temporary restraining order, okay? So after that, you're also going to prepare this document for the preliminary injunction. Okay, so you're going to be asking the court for a preliminary injunction. Now, a preliminary injunction is an injunction that's going to stay in effect through the duration of the case as you're moving your case down to the trial. So this will stay in effect. In other words, you would enjoin the company from being able to sell your software, for example, until this issue gets worked out. Now, that could have a devastating effect on their case. They may decide, well, we need to get this settled because we want to keep selling stuff. So, you know, that could give you a chance for settlement opportunities, something to bear in mind. But these documents are going to be prepared. Now, the preliminary injunction, again, because you're so set on having to be able to show the likelihood of success on the merits, you're going to need your declarations, your request for judicial notice, any other evidence that's admissible that you can get into that hearing, you want to get in, okay? Because again, you're going to have to show that you're likely to succeed on the causes of action that you put forth in your complaint, okay? So that's that. You're also going to want to prepare a proposed order. An order is the order that the judge would make on the preliminary injunction and saying that this is what I'm enjoining, you can do this, you can't do that, and this is the order of the court. Now, when it comes to injunctions, we'll talk about that in a second. There are two types. There's mandatory, which is saying, I want you to do this, like go destroy all the copies of infringing materials or something. That would be an example of a mandatory injunction. There's also what's known as prohibitory. Prohibitory may be, in this case, do not sell any more stuff on your website. Do not sell any software on your website that relates to this client's trademarks or their products. So that would be an example of a prohibitory injunction. At any rate, when you're preparing your package, your TRO preliminary injunction package, you're going to want to make sure you have all these documents lined up, all nicely put together. You're going to want to clearly define the scope of your order. Okay, so you want to be very specific because remember, if the judge grants the order, you're going to serve it on the other parties, anyone that would be affected by the order. Okay, but they need to know what's prohibited or what they're required to do, because realize people will try to work their way around these orders. Yes, they will try to work their way around these orders, or they may claim they're vague or ambiguous, or it wasn't preventing this when you think it was. So you want to be very specific and clearly define the scope of what you want the judge to sign. Okay, so bear in mind also in federal cases you need to be aware of chamber copies, making sure the judge is getting chamber copies. Finally, when you get an order, you're going to want to serve the order, and when you serve the order, that will bind the parties, their employees, their agents, their attorneys, so forth and so on. So you're going to want to make sure you properly serve the order. Now, another point is, in order to get the temporary restraining order under FRCP 65, you're going to need to post a bond, and the bond is to prevent against wrongful injunction. So if you're stopping this software company from selling your goods, your products, if it turns out you're wrong and they weren't actually infringing, now they have been damaged. So the judge will require you to post a bond in an amount that is sufficient to cover those potential losses. So when you're going into a TRO injunction type of setting, you want to make sure that you have evaluated what the potential damages are and seek out you're going to need to seek out a civil injunction bond company that provides these bonds, okay? So that is something very important. Don't miss that. If you're on the opposing side, if you're the law firm representing the software company that's being accused of software infringement, you want to make sure you're bringing up this bond requirement, saying, hey, wait a second, they can't do this without a bond. And if there happens to be wrong, there is some case law that says they can go move on the bond, at the close of the case or whatnot. So that bond is there to protect against wrongful enjoyment, okay? So we got that, not enjoyment, two different things. As I mentioned, when you're seeking the preliminary injunction and the TRO, you're going to want to lay out your case law. You're going to want to be very specific. showing how the facts fit the case law, and to show the judge and make that case that you're likely to succeed. So I can't emphasize that enough. Very, very important that you're likely to succeed, okay? What else? We got get court date, check your local rules, your chamber copies, we've got all that. We've got service of the order. The final point that I'll talk about is the permanent injunction, and that is when you get to the end of the case, assuming that you're the winner, you've got this software company to stop selling your goods, you can then seek the permanent injunction, asking the court to permanently bar them from doing what they're doing. That's the final permanent injunction. So that's really just the basics. This is not every nitty-gritty detail. This is a general overview, general legal information. If you need help in federal courts or California state courts, where we also practice, and you need an injunction or a temporary restraining order in a copyright or trademark case, give us a call. Business law case, we can help you, okay? Or real estate. We also handle business, real estate, intellectual property law, okay? So I hope this has been helpful. If you've enjoyed it, give me a thumbs up. If you have any comments, go ahead and leave them. If you need some more information, go to our website, FRCP65.com, FRCP65.com, and we have some more information there for you. Okay, hope this has been helpful. Attorney Steve, we'll talk again.